Our next story takes us to Broward County, Florida, where a family sued McDonald's because they say that one of the restaurant's chicken nuggets caused a serious burn to their child's thigh. A jury came back Thursday with a split decision. In court this week, attorneys for Falana Holmes and Humberto Estevez said a 200-degree McNugget fell out of the Happy Meal carrier and onto their 4-year-old's lap in the car. They say the nugget got stuck between the child's leg and the seatbelt, and was in there until Holmes could pull over and figure out what was going on. The family sued McDonald's as well as the franchise owner for negligence. The jury determined the companies failed to put warnings on the food, which led to the girl's injury, but McDonald's was found not negligent for causing the burns. The family is seeking $15,000, and attorneys say another trial will determine how much McDonald's and the franchise owner will have to pay in damages. Now, this lawsuit likely reminds you of the McDonald's hot coffee case from the 1990s, right? Because that became the poster child for so-called frivolous lawsuits. But it turns out a lot of what you might remember from that case isn't necessarily true. So we want to debunk some of the top misconceptions of that case. Let's talk about it. So first up, many people remember the victim in this case as 79-year-old Stella Liebeck spilling hot coffee on her lap as she tried to take the lid off and drive at the same time. In reality, she was the passenger in a car without cup holders. Her nephew Christopher was actually driving. After they went through the drive-through line, Christopher pulled over into a parking spot. Liebeck put the cup of coffee between her legs, pulling the lid toward her so that she could put in cream and sugar, and the entire thing spilled into her lap. It's believed the coffee was between 190 and 210 degrees. The sweatpants that she was wearing were seared to her skin, causing her injuries to be even worse. In fact, her physician said that they were some of the worst burns he had ever treated. There's another misconception, and that was that Liebeck was just out for as much money as she could get. But according to her family, she had asked McDonald's for a low amount to cover her medical costs. When she originally reached out to the corporation requesting that they cover her bills, McDonald's responded with an offer of $800. That's when she sued, asking for $125,000. It was the jury in the case that decided to award her $160,000 in compensatory damages and $2.7 million in punitive damages. But Liebeck never saw that much money. The amount was reduced multiple times, and the final amount was settled out of court. It's believed to have been around $500,000. Liebeck's family says that she used the money to pay for a live-in nurse. There's a third element of the trial that a lot of people latched onto. It is the duh factor. Of course coffee's hot, right? If someone spills it on themselves, it's not the fault of the restaurant that sold it. But during the trial, it was revealed that McDonald's knew of at least 700 instances of its coffee causing serious burns to people's bodies, even scalding children. The temperature of coffee someone got at McDonald's was far hotter than coffee brewed in a machine at home. Experts testified that serving coffee at a slightly cooler temperature would decrease the risk of third-degree burns. Even McDonald's quality control manager conceded that drinking the restaurant's coffee right after it was served could cause burns to a person's mouth and throat. All right, let's get into this. So Terry, the plaintiffs won the failure to warn claim, but what exactly is that, and what type of damages could they recover?
Well, failure to warn is a type of products liability case, and it's exactly what it sounds like when the manufacturer of that product doesn't tell the customer what they should do to take precautions. So you usually see it in cases for electronics, but here the product is the coffee, and here the product is that actual chicken McNugget. So they should have warned in the prior case and in this case. Now, if in fact they lose this case, the plaintiff could be entitled to economic and non-economic damages. So anything from medical costs and anything from lost wages, that would include the economic damages, and the non-economic damages would include like pain and suffering, and it would count for the pain and suffering of the family, including that child who apparently is very aware of that scar from that nugget.
Let's go back to law school, Brian. So the parents' lawsuit is suing for strict liability and negligence. Why both? What's the difference between the two?
Yeah, Jesse, you go for both because you want to see whatever theory could work for you. When it comes to strict liability, negligence, you might have also heard terms like recklessness, knowingly. These are levels of mental state or mens rea if you really want to go back to law school. Strict liability, it means it doesn't matter what you were thinking. If you did something wrong, then you are liable for it. And that's oftentimes for either the most absurd things that you do wrong, like having a coffee at 1,000,000 degrees Kelvin or blasting or certain type of dangerous activities. But negligence is when you do not take reasonable care. There are different levels of understanding, but doesn't seem they won on that. But as Terry described, they did have one claim that they won.
Okay.